Good morning, everyone. I'm going to just pause for a moment while everyone from our waiting room joins our virtual room here. So just give us a few minutes while this populates. All right, good morning, everyone. I think we have everyone in the room. So I'm going to go ahead and get started. Good morning. I'm Hearing Officer Nicole Kinsey with the Administrative Hearings Office of the State Water Resources Control Board. This is a pre-hearing conference for the hearing on the pending petitions of Consolidated Irrigation District, Fresno Irrigation District, and Alta Irrigation District, and Semi-Tropic Improvement District of Semi-Tropic Water Storage District to revoke or revise the declaration of fully appropriated stream systems with respect to the Kings River system on a potential revocation of water right licenses 11517 and 11521, and on a proposed cease and desist order against the Kings River Water Association and its member units. This pre-hearing conference is being held in accordance with the hearing officer's pre-hearing conference ruling of February 19th, 2021, and the amended notice of public hearing and pre-hearing conference that just went out dated March 19th, 2021. This pre-hearing conference is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. Both the audio and video are being recorded, and we will post files of this recording and also the Zoom generated transcript to the AHO FTP site. The YouTube recording will also be available on the AHO's YouTube webpage. If you're experiencing technical difficulties today trying to communicate with us, please send an email to the AHO at admin@waterboards.ca.gov. The AHO staff will be monitoring that email inbox. Assisting me today are several staff of the Administrative Hearings Office. We have Nicole Mullen, Amy Blanc, Megan Nyes, Skylar Anderson, and Kyle Woldridge. I'd like to move now to appearances. I'm going to try to move through this a little more efficiently than last time. To do that, I'm going to identify each of the entities that filed initial NOIs. And as I do, if you are representing that entity today, please unmute your microphone and state your name. I will start with Semi-Tropic Water Storage District, please.
Good morning, Ms. Kinsey. Kevin O'Brien representing Semi-Tropic, and my colleague Sam Bivens will also be appearing, and Mr. Bivens will actually be taking the lead today.
Great. Thank you, Mr. O'Brien, and thank you, Mr. Bivens. Good morning.
Good morning, Ms. Kinsey. This is Steve Torgiani, General Counsel for Semi-Tropic Water Storage District.
Good morning. Thanks for joining us.
And one more. Good morning. This is Brett Stroud, also from Young Woldridge for Semi-Tropic.
Good morning. Thank you very much. I'll move on to Kings River Water Association.
Good morning, Joe Hughes on behalf of the Kings River Water Association.
Good morning, Mr. Hughes.
And also with me is Leonard Herr, also on behalf of the association.
Thank you very much. Alta Irrigation District, Consolidated Irrigation District, and Fresno Irrigation District.
Good morning. This is Nick Jacobs representing Alta Consolidated and Fresno Irrigation Districts.
Good morning, Mr. Jacobs.
Good morning. This is Lauren Lane from Baker Manikin Jensen representing Alta and Consolidated Irrigation Districts, and I'm joined by my colleague Doug Jensen.
And good morning. Thank you.
Good morning, Ms. Lane, and good morning, Mr. Jensen.
This is Jeff Boswell, General Counsel for Fresno Irrigation District.
Good morning, Mr. Boswell. All right, let's move on to Tulare Lake Basin Water Storage District.
Good morning, Ms. Kinsey. Peter Keel for Tulare Lake Basin. I'm joined by co-counsel Aubrey Moritzen and Josh Fox.
Good morning, Mr. Keel, and good morning to your colleagues. Thank you for joining us. McMullen Area Groundwater Sustainability Agency.
Good morning, Ms. Kenzie. Robert Donlin for the McMullen Area Groundwater Sustainability Agency. I'm joined today by my colleague Shonda Grady.
Good morning, Mr. Donlin. And then, well, I'll go ahead and read off all the names. Ms. Spalletta, I may be jumping the punch, but I'll read the names so that we have for the record the NOIs that we've received. Laguna Irrigation District, Burrell Ditch Company, Stinson Canal and Irrigation Company, Upper San Jose Water Company, Liberty Mill Race Company, Liberty Mutual Canal Company, and Clark's Fork Reclamation District.
Good morning, Jennifer Spalletta, Spalletta Law for Laguna Irrigation District et al.
Great. And will you please confirm, did I get, is the et al that I read the right list?
You are correct.
Thank you. People's Ditch Company and Last Chance Water Ditch Company.
Good morning, Ken Richardson, Peltzer and Richardson on behalf of People's and Last Chance.
Great, thank you. Good morning, Mr. Richardson.
Thank you.
Terra Nova Ranch, Inc.
Good morning, this is Zach Smith for Terra Nova Ranch.
Good morning, Mr. Smith. And California Department of Fish and Wildlife.
Good morning, Kathleen Miller with CDFW, and I'm joined by Nancy Murray.
Good morning, Ms. Miller. Good morning, Ms. Murray. That is my list of NOIs. Is there anyone who is here representing a party who filed an NOI and I missed you off the list? Is there anyone else on the line who would like to introduce themselves joining us today? Great. That was efficient. Thank you. As we proceed, please keep your microphone muted except when you are speaking so that we can minimize the background noise and unnecessary interruptions. And if possible, please enable your camera so that we can all see each other. Thank you for all of you for doing that. I think soon we'll know each other well enough that we can drop those instructions, but for now, we'll keep them up. I'll talk a little bit about how I'd like to run this pre-hearing conference today. Thank you for joining me. The purpose of this pre-hearing conference is to address procedural issues related to the conduct of Phase 1A of the hearing. The AHO received pre-hearing conference statements from Semi-Tropic, KRWA, and Tulare Lake Basin Water Storage District. So thank you for those. I've read them, they're helpful. The AHO also received KRWA and Tulare Lake Basin's motions to quash the subpoenas of Semi-Tropic and Semi-Tropic's opposition to those motions to quash, and I've read those carefully as well. We'll get to those issues in the moment, but this is how I'd like to proceed today. First, Tulare Lake Basin identified some documents that it recommended. I'm sorry, Mr. Jacobs, I see a hand.
Did you also receive the pre-hearing conference statement from my clients, Alta, Consolidated, Fresno?
I don't see that in my record, but I am going to turn to staff and have them, Ms. Mullen, will you please, or the rest of the AHO team, will you please take a look and make sure we have those in our record and that there wasn't an error? And I apologize, Mr. Jacobs, if there was.
That was sent last week.
But I don't believe I saw it in my files. So I will give you, if it is the case that we didn't see those, I certainly give you a little more time to speak today and address any of the issues, and I apologige for that. I'm waiting for my team to come back to that. Let me identify how we're going to proceed, and we'll come back. So first, Tulare Lake Basin identified documents that it requested to be included, or I should say recommended, I think that was the language, to be included in the hearing, the administrative record for this proceeding. And I just wanted to march through some of those and talk about the logistics of that first. Hopefully we can knock that out. Second in the list, I'd like to address the pending discovery motions, or at least talk about them. I'm not planning to rule on those today, but I would like to hear from you on those motions. Number 3 is the issue of rebuttal, which most of you raised in your pre-hearing conference statements. I think there was agreement to allow rebuttal, but I would like to talk about how to structure rebuttal and to do that efficiently for Phase 1A. And then finally, we'll turn if there are any other issues to address today. And we'll also talk about setting up a status conference sometime before the Phase 1A hearing. I'm looking to my team. We don't see, Mr. Jacobs, we don't see the pre-hearing conference statements. If you would please resubmit those to us. You have our email address. You can also upload them to the FTP site. The
Sure.
FTP2 is a way to get those to us. Once again, I'm not sure what, we have had some issues with our email inbox, so I apologize. It may be a technical problem. We've had some of our emails funneled off into a spam folder. We've
Okay.
been trying to work with DIT to correct that, so I apologize in advance. In the future, for all of you, please do check the FTP site where we keep that administrative record. If you don't see, we try to upload our documents pretty quickly there that we receive, usually within a day or two. If you don't see the documents there, that probably means there was some problem in our receipt of those. So I apologize again, but maybe going forward, we can address this and we will work with DIT to straighten out our email. So we'll start with Tulare Lake. Mr. Keel, I'm going to, I think, look to you. You identified 5 categories of documents that you recommended be added to the administrative record. I think first on the list was a January 1st, 2020 email from Semi-Tropic to the Division of Water Rights Enforcement Unit. And I think that particular email would be appropriate to have in our record, but it raises the more general issue of whether we should have the entire enforcement unit's entire public file related to that complaint, which I think would be appropriate to have in our record. So what I'm going to do is I'm going to send an email to the division's enforcement unit. I will CC all of our service lists, so all of you will see that email and request for them to make an electronic copy of their complete public file related to the Semi-Tropic complaint and submit that to us. And then I will, or our team will upload that to the FTP site and our administrative record so that it will be available to everyone. So if that January 1st, 2020 email is in their records and we still have it, that should appear in that block of files. Otherwise, I just don't know if it's there, if it was retained, but in theory, it should be in there and we should be able to track that down and include it in the record. Mr. Keel, is there anything else on that particular record that you want to add?
No, thank you. We appreciate including those files.
Great. So the other documents that you identified, I think first we'll talk about the 2 applications, and then there's Decision 1290, the hearing exhibits and the hearing transcript. At this time, the AHO doesn't have electronic copies of those. I suspect they're rather large. I don't know that, but I suspect they're rather large and there might be many exhibits. So if the recommendation is that we move these into our electronic administrative record, of course, they're in the State Water Board's public files, so we can incorporate into the record by reference. But to the extent we want them an electronic copy and want to make those available, I think it would be up to one of the parties to obtain those documents electronically. I believe our records room is now open and at least has staff in it and is running and is operating, and that records can be made available. They should be available to assist in getting those documents copied. If you have any trouble related to COVID restrictions and that kind of thing, I can try to assist with that and see if we can get those documents made available. But I think that would be up to the parties to make those copies and submit them if we want to have them in our electronic file. I'll move on and then I'll get back to you, Mr. Keel. I'll just move on to the other 2 issues. You also identified the Pine Flat Water Control Manual. I don't know that that would be in the State Water Board's files. It may. I don't know that related to these licenses. I suspect it's not. And in that case, it's probably most appropriate that that would come in through the exhibit process. We're looking, that administrative record that we've placed online is all matters that are within the State Water Board's files. So to the extent we have documents that are outside of those files, I think those should come in as exhibits. The expected KRWA revised reports of licensee, I think let's pause on those and deal with those when they actually are filed. I'm not sure if it makes a difference whether we just bring them in as a matter through our administrative record or whether they come in as an exhibit. But if it's a concern that some of them are filed after the exhibit submittal deadline, I think we can deal with that at that time. So my proposal would be to set that off until those documents are actually filed with the State Water Board. With all of that, Mr. Keel, is there anything you would like to add on those issues?
No, I generally support your recommendation. I will work with other counsel in reviewing some of the electronic files we have for Decision 1290. My concern is that some of the copies that I've attained appear potentially incomplete. And since we have had difficulty processing documents through the file room, I wanted to raise that as an issue, and I thought that we could use your assistance. I know that Counsel for MAGSA contacted me about access to citing some of the similar delays. So I'd say it's still an outstanding issue, but we will work with your office to provide those in the record. And
Great, thank you. And please let me know if there are specific documents, pages that if the copies are poor, those kinds of things. Let us know, and we will try to work in getting those into the record if it's a records room issue.
Thank you.
Does anyone else have anything to add on this issue of these records?
Ms. Kinsey, this is Sam Bivens for Semi-Tropic. I generally agree with your ruling and certainly wouldn't object to the first 4 categories of documents being included in the administrative record. I do think with respect to the revised KRWA reports of licensee that may or may not ultimately be filed, that we'd just like to reserve all of our evidentiary objections to those, and that those files should be dealt with through the evidentiary process at the hearing, rather than just included in the administrative record wholesale. But as you're inclined to do, I think we can set off that more intensive discussion until they're actually before the hearing officer.
Thank you for that. And I'll just say generally, I think our practice has been, and I believe will be going forward, that the documents that end up in our electronic administrative record that the HO staff bring in are documents that are in the public files for the State Water Board at the time the hearing notice is issued. And that's generally been our cutoff date, which is one of the reasons I wanted to defer this issue of the KRWA reports that have not yet been filed. But we'll deal with that when we get there. Are there any other comments on this issue? Well, let's move to, I think, well, one of our bigger discussions, the pending discovery motions. I'll just reiterate, the AHO received KRWA's motion to quash the subpoena Duces Tecum of Semi-Tropic Water Storage District and the similar motion from Tulare Lake Basin. These were received on March 15th and 16th. The AHO received an opposition to these motions from Semi-Tropic on March 19th. And then in addition to those subpoenas, Semi-Tropic also issued subpoenas for the deposition of 2 witnesses. These are dated March 12th. Based on our files, I don't think there are pending motions with respect to those 2 deposition subpoenas, but I wanted to identify those as well. I realize that's part of our discussion. As I said, I'm not going to rule on the motions to quash today, but I realize that it's an important issue and we need to deal with it pretty quickly if we're going to the extent that it may affect our schedule. So I anticipate I'll rule on the motions pretty shortly after this pre-hearing conference. I have read the motions, I've read the opposition, and I would like to hear from you if you have anything to add to your written materials today. And as I said, I realize we don't have pending motions with respect to the deposition subpoenas, but this would be an appropriate time to comment on those as well, if there's anything you'd like to say with respect to those. I also have a couple of questions I'd like to ask about the discovery items, but I think I'm going to pause and I'd like to hear from you. I'd like to start with the recipients of the discovery. So I'll start with KRWA and then I'll move to Tulare Lake Basin. And then I'll ask to hear from Semi-Tropic, and then we'll move to anyone else who would like to comment on these issues. So I think Mr. Hughes.
Thank you, Ms. Kinsey. As you noted, you've read the motion, so you've read the authorities that we laid out. What I would want to emphasize is that from a procedural standpoint, my understanding when we began this process back in January was that we were all putting our cards on the table in terms of what the process was that we were going to follow. And so as we laid out the timeline of events, everything was supposed to be on the table. And so we chose the hearing dates with you and the timeline for submissions, which would work with us. And so the position that we're in now is that if we're going to be responding to discovery and taking depositions and whatnot, okay, maybe, but at the same time, that's going to impact the schedule that we laid out. From KRWA's standpoint, and I think we advised the hearing officer of this back in December when we pointed out some issues that we had with the schedule, is that KRWA does have fairly significant trial set for the middle of April, which is going forward. And so for the next few weeks, we will be doing, as some would say, all the things that should have been done maybe a couple months ago, and that we're taking the final round of depositions. We just exchanged expert witness designations yesterday. So that's the quote unquote fun that we'll be having for the next few weeks leading into the April trial date, which probably, because as I've mentioned at the last pre-hearing conference, is a bench trial, may slide somewhere in there. There may be days on and off through the balance of May and perhaps into April and into May. But in any event, one of the things that we KRWA tried to do from the outset is put our cards on the table in terms of these are the issues that we have from a scheduling standpoint. And so when we received the record subpoena and then the deposition notice, if you will, we were somewhat taken aback in that there was this desire for discovery, which was not laid out before in terms of how that was going to fit into this process. And our hope, and we had been, I think, doing this in a fairly orderly fashion. So aside from the authorities that we cite in our motion, I just wanted to emphasize that we really felt that the discovery should have been part of the discussion in terms of process and procedure. And if we want to have that discussion now, that's fine. But I recall that it has been Semi-Tropic all along that has wanted a quote unquote expedited hearing date and have this thing heard as quickly as possible. So I'm just not sure that they can have their cake and eat it too on this.
Thank you, Mr. Hughes. Can you speak brief? I don't know if to the extent you're able to speak to this, the scope of, or the burdens, I suppose, that would be involved in responding to the document subpoena. The categories at least appeared fairly broad, but I don't know if you have a sense of what that would entail or what that would involve and have any comments on that today.
Yes, thank you, because that was the other item that was somewhat shocking to us, in that it goes back seeking records back to 1984. And so in terms of reviewing all of KRWA's records, for example, communications with the Army Corps of Engineers, I believe that one in particular goes back to 1984. And so again, the scope of this would require a fair amount of time on behalf of KRWA staff to pull that and make sure that it is being produced properly. And so again, in light of the other activities that we have going on right now, was burdensome in and of itself, but unduly burdensome given the timing of Semi-Tropic's discovery. So long way of saying, Ms. Kinsey, that in terms of the scope and breadth of it, it's a lot of paper.
Mm-hmm. And may I just add to that?
Yes.
My name's Leonard Herr, and I've assisted KRWA in filing the motion. I'm also one of the trial counsel for the case that's scheduled to go to trial early next month in Kern County. Steve Haugen, as you all know, is the water master. Steve has been our primary contact in the case that's scheduled to go to trial next month. He has been working diligently to help us get ready for trial. Steve is also a non-retained designated expert in the civil case that's set to go to trial next month. So in addition to just the vast volume of documents being requested, this is creating a serious burden on Steve's time because I really do need him to prepare to depose the other side's experts. We also need him with regard to trial preparation, and just in terms of his ability to serve what I'll call the Semi-Tropics matter, as well as the litigation, is really creating just a tough time for him. So I just wanted to add that to what Joe Hughes said.
Thank you, Mr. Herr. Mr. Keel, do you have any comments that you would like to add?
Defer to my colleague, Josh Fox, please.
Great. Mr. Fox?
Thank you, Hearing Officer Kinsey. I did have an opportunity to look at Semi-Tropic's opposition. I would note that Semi-Tropic appears to be really hanging its hat on what it perceives to be the plain language of regulation, Section 649 .6. And since it's invoking the plain language of that regulation, I think that it would behoove us to examine the language of that regulation. It provides that the board may issue subpoenas and subpoenas duces tecum for attendance at a proceeding and for production of documents at any reasonable time and place or at a hearing. So one thing that's clear is that the reasonable time and place proviso does not apply to attendance at a hearing. It therefore follows that a witness's testimony may not be compelled pursuant to this section. And I note that primarily in the context of the presumptive oral depositions that have now been noticed by Semi-Tropic of Mr. Bricker and Mr. Haugen. Those oral I know this is not in front of the hearing officer, however, it is pertinent to discovery authority. So it's clear to me that section 649.6 only applies to business records subpoenas for records. So no oral authority to produce a witness other than at a proceeding there very clearly. So the residual question then in terms of interpreting the plain language of that section is, why would the board say you can only compel witnesses to attend the hearing, but for documents we'll let you deliver them to a reasonable time and place or at the hearing? It seems clear to me that the implication there is that the reason for that proviso is so that documents are not produced on the date of the hearing. It's a logistical matter. And this interpretation bears out. And I think the reason that witnesses cannot be compelled pursuant to this section to attend oral depositions is because the board didn't have oral depositions or any other type of pretrial discovery in mind when it enacted section 649.6. And moreover, on any plain language reading will investigate the statutory context of any statement. So you can't simply take a few words, any reasonable time and place, and attempt to interpret them outside of statutory context, outside the context of the statutory setting. When we look to other aspects of that setting, that's where we see clearly that where pretrial discovery is intended by the legislature, it is permitted explicitly, as we see that for formal proceedings under section 11500 and following, as we obviously see in the Civil Discovery Act. On Semi-Tropic's view, these few words, reasonable time and place, do a ton of work interpretively. They create an additional phase for the entire hearing. That to me, it's not something that would have occurred absent explicit legislative instruction. And we see examples of that throughout. Counsel for Semi-Tropic mentioned a resolution 999-021. If one simply takes a look at that resolution and all of the different sections that were enacted by the board, along with the section for subpoenas, it's very clear what the board was doing. It was structuring its evidentiary hearings. It was not creating a bifurcation in proceedings whereby there's a discovery phase and then a trial phase. It simply was not doing that. So as a matter of statutory interpretation, you can't make those words, any reasonable time and place, do the Herculean work that Semi-Tropic is asking it to do. I would also note that Semi-Tropic in its opposition completely disavows any application of Water Code section 1100 and its requirement that any deposition subpoena follow the prescriptions of the Civil Discovery Act. I would note that the addendum to the subpoena, part of the subpoena itself states, and this is a statement by Semi-Tropic when it issued the subpoena, pursuant to the provisions of Water Code section 1080 and 1100 and so on, my client, the district, is commanded to provide following documents. So it was sufficient basis for them to command the production of documents. When they issued the subpoena, now they disavow its application. I find that curious. But it is very clear that Section 1100 applies the Civil Discovery Act to any subpoena. It's also equally clear that under the Civil Discovery Act, what was issued was a deposition subpoena. It was a subspecies of a deposition subpoena, a subpoena for business records. And there are very clear guidelines for that. Those have been not followed here. And finally, the argument that the subpoena designates a reasonable place and time is just a non-starter. And I would note on this issue, Semi-Tropic is trying to turn it into an argument about us making some affirmative defense regarding the burdens of the discovery. So this is not a case where we received an otherwise lawful subpoena and now we're just arguing about the burdens. That's not correct. And so if that were the case, I agree we should get into much more detail about the burdens, but where and the legislature has clearly required of any subpoena that it designate a reasonable place and time in order to be authorized by those sections. So if you don't designate a reasonable place and time, it's not statutory, the subpoena is not statutorily authorized, and that's why we're moving to quash rather than entering into a discussion about the relative burdens, which, given the scope of the subpoena, I guess given the scope of the subpoena, it just goes to how unreasonable the time and place for deposition were here. So that statutory requirement was not met, and a motion to quash is proper where the condition simply hasn't been satisfied.
Thank you, Mr. Fox. I think would it be fair to say, as I understand, I think much of what you mentioned here, particularly with respect to the language of the regulation, I think was in the motion to quash, but you're extending, as I understand, you're extending that argument to address the deposition subpoenas as well. Would that be an accurate understanding?
Right. It's that my statutory argument is a part and parcel of any a sufficiently intelligent statutory argument about plain language. Plain language is always in context, never taken in isolation.
Thank you, Mr. Fox. I believe next, Semi-Tropic, Mr. Bivens on behalf of Semi-Tropic.
Thank you, Ms. Kinsey. Well, I want to take Mr. Fox up on his offer to interpret the language of Regulation 649.6 in Water Code Section 1080 in its proper context. And I think the best way to do that is to start with the subpoena form that the State Board makes publicly available on its website, and in fact informs attorneys that they have the authority to issue it on their own as a matter of right without prior authorization from the State Board. So if you take a look at that State Board subpoena form, and there's a link in I think the second paragraph of my declaration, if that's convenient to you, it's pretty clear that the way the State Board interpreted its own authority is to have attorneys issue these subpoena forms is entirely in line with Semi-Tropic's position. And in particular, if you look at that very first box at the top, there are 4 check marks. One for subpoena, one for subpoena ducis tecum, one for re hearing, and one for re deposition. So I cannot conceive of any reason why the State Water Board would make deposition subpoenas available for attorneys to issue as a matter of right if it didn't believe that Regulation 649.6 and Water Code Section 1080 allowed it to make these forms available and for attorneys to do exactly that. As far as the technical objections that Mr. Fox briefly alluded to, I think those are pretty well addressed in our briefs. I don't want to go into them in any detail. I do want to be very clear, though, again, going back to the subpoena form, that there is no citation to Water Code Section 1100. And there are statutory and regulatory citations all over the subpoena form. The State Water Board was very thoughtful in considering what authority it had to make these forms available for attorneys to issue on its own. Mr. Fox is correct that my affidavit in support of the subpoena mentioned Water Code Section 1100. Mea culpa, shouldn't have been in there. I recognize that, but legally it's irrelevant to the issue of whether Semi-Tropic has the authority to issue these subpoenas as of right. I want to turn just very briefly to Mr. Hughes and Mr. Herr's comments about the burden associated with these subpoenas. And I want to be clear that, as we mentioned towards the end of our opposition brief, it's a little bit late for these arguments about burden to be raised now. As the moving parties on these oppositions to motions to quash, KRWA and the Tulare Lake Basin Water Storage District have the burden of producing evidence showing the quantum of work required and the level of oppression that's going to be involved in responding to these subpoenas. And they haven't done that. There's nothing in either declaration in support of those motions that addresses the quantum of work required to respond to these subpoenas. And I just want to be clear also, despite the fact that that KRWA and Mr. Haugen are preparing for a trial, I understood from my last conversation with Mr. Herr that they are also in the process of collecting documents that are responsive to these subpoenas. So I'm really not sure what the burden there is if they're already engaged in the work to make these documents available to us, as they should do. And then very briefly, with respect to the pre-hearing conference, I think we did put everything on the table that we needed to in terms of our schedule. I didn't see anything in the pre-hearing notice that required us to reveal our discovery strategy in great detail, clear it with you and give the other parties a chance to object to that strategy. I think you laid out the hearing issues pretty clearly and everyone addressed them. And I haven't heard anything yet, no evidence whatsoever that suggests that the schedule is going to need to be changed to accommodate these discovery requests. And the same is true with the deposition subpoenas that were issued to Mr. Bricker and Mr. Haugen. One last thing, and then I'll stop. There's no dispute that the depositions we've requested and the documents that we've requested are directly relevant to phase 1A. There's no question whatsoever. And so to the extent that you intend to sustain any of the technical objections that are associated with the motions to quash, I want to also make it clear that you have a great deal of discretion under Code of Civil Procedure Section 1987.1 to direct compliance with the subpoenas in any event. And to the extent you're inclined to sustain those objections, I hope you'll exercise that discretion. There is a significant information gap between the parties in this case. This is not, a stream like the Sacramento River where there's an exceptional amount of publicly available data for Semi-Tropic to analyze. And we've just got to get that information from the KRWA and the Tulare Lake Basin Water Storage District in order to effectively prepare for phase 1A. And I think we're fully prepared to do that and move forward in the context of the current hearing schedule. Thank you.
Thank you, Mr. Bivens. I think you set me up nicely for one of the questions that I had for you, which I believe in your, and I'll read it because it was in your pre-hearing conference statement. I believe you said, Semi-Tropic's allegations and publicly available evidence in support thereof, I believe from the complaint, are sufficient to conduct an evidentiary hearing on the issue of whether KRWA's licenses should be revoked. And you just mentioned the need for these documents and the importance to phase 1A. And I'm just wondering if you could address why phase 1A? Why are we doing discovery in preparation for phase 1A? Isn't this a phase 1B issue? I'm just trying to, can you comment on that? If Semi-Tropic believes it has the information it needs to prove its case for phase 1A, would it not be more efficient or more appropriate to move to this question of discovery at a later time?
Of course, and I think that's a great question, and it's exactly one of the points that I had hoped to make to you today. We had previously been very clear in our past pre-hearing conference statement and our prior correspondence during the month of December with you in response to KRWA's procedural objections to the statement of facts of information that was included in the hearing notice, and that we could move directly to what is now phase 1B without a whole nother evidentiary proceeding, and that the evidence on which the complaint was based was already available to the other parties. The other parties disagreed with that, and I think you may have disagreed with that because you decided to move forward with a phase 1A hearing. So having put all of this evidence and these allegations on the table for everybody to take a look at, the position that the other parties have taken is that that's not good enough to get to phase 1B. That's their implicit position. And so I need to be able to make a really fulsome record on phase 1A so that we can move along to phase 1B. Now, I want to be clear, if the other parties are willing to stipulate that there is sufficient evidence to support the statement of facts and information that was included in the original hearing notice and move directly to phase 1B, that's certainly something we'd like to consider and talk about. But as of this point, they're taking the opposite position.
Thank you. Understood. One other question I had, as you may know from practice in front of the State Water Board, I realize the AHO is a new office and we're running our hearings a little bit differently and learning to do that, and we're all adapting together. So thank you for your patience. But in general, the hearings before the State Water Board haven't involved pre-hearing discovery. One of the reasons for that has been because there's an opportunity for cross-examination, right? If these witnesses, I'm thinking specifically with respect to the deposition subpoenas, if these individuals are called as witnesses, at that time, Semi-Tropic would have an opportunity to cross-examine them. And in general, cross-examination is not limited to the scope of direct testimony in our administrative hearings. So I'm wondering if you have any comments on that as to whether, given that you will have an opportunity to question these individuals, whether there's a timing issue there. I see your hand, Mr. Fox. I'll give you a chance to respond, but let me hear from Mr. Bivens first.
Well, certainly, and this goes back to my point that there's a pretty significant information gap between Semi-Tropic and the other parties to this case, that there's not a lot of publicly available data. I want to be clear that what I'm attempting to engage in here is fact discovery, and about facts that are uniquely in the possession of the KRWA Water Master and Tulare Lake Basin Water Storage District officials. To have to obtain those facts, given the overall context about the dearth of publicly available information in the public record with respect to Kings River Water Association operations, hydrology and flood control operations, as well as their water use, having to do that on the fly in a hearing is, I don't think really provides Semi-Tropic with a reasonable opportunity to be heard on these issues.
Thank you, Mr. Bivens. I'm going to, I'll just lay this out. I'll move to Mr. Fox. I'd like to hear from KRWA if you have any comments. I'd like to hear from other parties, and then we'll wrap up and see if Semi-Tropic has some closing thoughts. We'll hear from you too. So each in turn, Mr. Fox.
Yes, thank you, Hearing Officer Kinsey. I just want to note that in the rare circumstances where discovery has been permitted in contexts such as these, the rationale has not been private parties are entitled to pre-hearing discovery against each other. The rationale has been provided in a context where a person is facing or private party in any event, presumably in most cases a private party, is facing the machinery of the state board, along with accusations from the state board that are significant in terms of due process of the sort one would associate with a law enforcement proceeding, right? And so there's this notion of basic procedural fairness that gets triggered when the state board files an accusation. In this case, any sort of due process interest in discovery, it's at its lowest point possible. The state board hasn't filed an accusation, a Semi-Tropic has, and the state board has said, hey, I don't really think this accusation works at all. Do you have anything else you want to file? And they said, no, we're fine with this amended complaint. And now they're claiming a right to discovery. Normally, if the state board had found merit and chosen to basically make charges based upon that complaint, then my client would have some sort of inherent right to discovery. But in this context, the private party who's making the baseless allegations has no such right. Also, the idea that the availability of subpoenas on a website somehow authorizes an pre-hearing discovery is just without merit. I would note also that attorneys can subpoena parties normally in connection with a hearing or trial. So that would explain their availability as well. And third, to this repeatedly mentioned information gap, that was something that should have been cured before the allegations in the complaint were made and before the complaint was submitted. If it had been vetted that way, the state board could have taken it up. However, it wasn't, and the board can't. So an information gap merely speaks to the fact that a complaint was filed 3 years ago without supporting evidence.
Thank you, Mr. Fox. Mr. Keel, do you have any comments on these issues?
No, thank you. I think Mr. Fox summarized TLB's position on pre-hearing discovery and the oddity of phase 1A regarding Semi-Tropics complaint quite well. I guess if I could take just the opportunity to ask for the AHO's clarification on process moving forward. What we interpret to be the basis for phase 1A is solely Semi-Tropics complaint, that the AHO did not adopt that complaint as its statement of information for any notice of proposed revocation and cease and desist order. So I believe we are here in 1A to essentially to debate and gather evidence on Semi-Tropics complaint. If that's correct, I'd appreciate you confirming that and also just kind of describe the process moving forward in 1A. Does Semi-Tropic have a burden of proof? I admit that I don't fully understand these procedures and I would like your help in understanding.
Well, I'll refer to, thank you, Mr. Keel. I'll refer to the amended hearing notice, which was recently issued. The intent of that amended hearing notice was to clarify some of these issues. This is all new. I, like you, have not conducted a phase 1A hearing. So we are moving forward together. What I did in the amended hearing notice, which I'll leave to you to read for yourself, is lay out the issues for the scope of the hearing and lay out what it is that the AHO is considering, which is whether there's sufficient evidence to move forward and notice a phase 1B hearing. And that notice, as statutorily required, would include a statement of facts and information with respect to the relevant matters for which there's sufficient evidence to move forward to phase 1B, if there is sufficient evidence for a phase 1B. Now, with respect to the scope of phase 1A and Semi-Tropics complaint, the amended hearing notice does not limit the scope to the issues raised in Semi-Tropics complaint. That it does not say that. There could be other issues. The other parties have an opportunity to present their own evidence. Semi-Tropic has the opportunity to present its evidence with respect to whether or not there is sufficient evidence to move forward with a notice and a statement of facts information with respect to the revocation of those 2 licenses or consideration of the revocation of the 2 licenses and consideration of a CDO. So I do not interpret at this time the amended notice as necessarily limiting the issues to Semi-Tropics complaint. Semi-Tropics complaint isn't directly incorporated into the statement of the hearing issues and the scope there. So you can take a look at it for yourself, but I do want to clarify that. And I appreciate you asking clarifying questions because I do want to go into this with a clear understanding from everyone as to what it is that we're doing and the scope of what it is that we're doing, so we can set this up properly. Is there anything to follow up on that, Mr. Keel? Not proposing that you may have future questions, but I refer to the amended hearing notice.
We will take your suggestion to reread the revised notice and we'll let you know if we have further questions.
Thank you.
Thank you.
I want to move to the other parties, if there are any comments on the discovery issues. And then I'll go back to Mr. Bivens to see if he has anything closing to say. Mr. Jacobs, I saw your hand.
Thank you, and I'm still not sure why you didn't receive our pre-hearing conference statement.
Thank you.
I do believe the other parties did. I know Semi-Tropic referenced it in their pre-hearing conference statement.
Yes, they did. It should have tipped me off. I was going to ask you, and I'm sorry to interrupt. Did you send it via email? Was I correct in assuming that you sent it to the hearing office via email? That might help us track it down.
My secretary served it and filed it, so I have to follow up with her after this.
Okay.
call.
Thank you.
Yes, so my clients support KRWA's position on this. We don't believe discovery is appropriate ahead of phase 1A. Believe it should have been addressed in the initial pre-hearing conference so that all the parties could have a chance to engage in that process, and that the schedule could be adjusted appropriately so we're not all jammed up. I hope the hearing officer gets a chance to go back and review the letter exchange that happened at the beginning of 2020 between Mr. Hess of the Enforcement Division and Semi-Tropic, in which the Enforcement Division clearly states that the complaint cannot be processed without additional information or revisions. And in response, Semi-Tropic says, you have all the information you need. We will not revise the complaint. That was a year and 3 months ago. And here we are today seeking discovery. On the statutory authority for these deposition subpoenas, the depo subpoenas clearly are under Water Code 1100. The fact that Semi-Tropic's counsel is trying to walk that back should be a red flag for the hearing officer. In particular, Water Code Section 1100 incorporates the procedures of the California Discovery Act. There is a critical provision of those rules that talks about the cutoff of discovery so that parties aren't jammed up ahead of their trial. Okay, and this is cited in our pre-hearing conference statement, but that rule states, I believe it's California Code of Civil Procedure Section 2024.020A. That's the 30-day discovery cutoff. And that discovery cutoff is from the original trial date in the matter. Our original trial date, hearing date in this administrative matter was April 15th or 16th. So we are well within the 30 days of that. And that prohibits these deposition subpoenas as well of all the information that you've heard so far. Again, if there's going to be discovery ahead of phase 1A, we would ask that you adjust the schedule and let all parties engage in that. I would be interested in doing discovery into what happened between Mr. Hess's letter saying State Board can't process this complaint, Semi-Tropic saying you're not getting any additional information, and now we're processing the complaint. That would be a topic of interest to me. I'll move on now to, I think it is super important. I think it might've just been an omission, but in our initial schedule, we had a rebuttal phase that was a month out from the case in chief submittals. And I think that is super important to put that back in. It was omitted from the most recent schedule that you sent out. I think it's especially appropriate in the context of the complaint that KRWA gets a full chance to respond to whatever case in chief is put forward by Semi-Tropic. These two licenses, which have been relied upon for water in diversions in 3 counties for decades, are super important. They're super important for a number of reasons, including the ability of these counties to comply with SGMA going forward. So I'd like to raise that issue as well. I think the rest of it has been covered well. And so those are my comments. Thank you.
Thank you, Mr. Jacobs. And we are going to talk next on the list of things to talk about explicitly is rebuttal. I do want to talk about that to some extent. I also wanted to let you know that as you were speaking, I was alerted that your pre-hearing conference statement appeared in our inbox, so your team must be working in the background. So we now do have it, and I will certainly read it right after this conference. Thank you for that. Are there any other parties who would like to comment before I turn back to Semi-Tropic on the issue of discovery? Mr. Bivens, do you have any closing thoughts that you'd like to share on this?
Yes, thank you. Just 3 hopefully fairly quick points, Ms. Kinsey.
Thank you.
First of all, you referred to the amended hearing notice as not limiting the scope of phase 1A to Semi-Tropic's complaint. And I think that's really, really important. One of the arguments that we have seen against Semi-Tropic's complaint, in defense of Semi-Tropic's complaint, are these arguments about the flood control manual, that the flood control manual somehow prevents the KRWA and its members from fully exercising their rights under licenses 11517 and 11521. I think Semi-Tropic needs discovery to prepare to meet that argument in its case in chief. I think we've got to be able to have the information necessary to address these new arguments about the flood control manual and the effect that it has on semi-tropics water availability analysis and forfeiture and abandonment analysis. So that's the first point. The second point I want to make, and this is a theme actually throughout the pre-hearing conference statements, not the oppositions to the motion to quash, of course, but the pre-hearing conference statements. And that's this attempt to sort of muddle the lines and confuse the issues as between the enforcement division's exercise of its prosecutorial discretion not to bring an enforcement action on the complaint, and the state board and the AHO's authority to decide whether a cease and desist order should be issued, whether these licenses, the Tulare Lake licenses, should be revoked, and ultimately whether the semi-tropics FAS petition should be granted and water rights application processed. Those are, in my mind, very, very distinct issues. And I think the state board recognized that when it referred the issue of semi-tropics complaint and semi-tropics FAS petition to your office for hearing. Finally, I just want to address Water Code section, Mr. Jacobs' arguments about Water Code section 1100. And frankly, I'm a little bit puzzled that Mr. Jacobs is asserting these arguments because none of his clients' representatives have been subpoenaed for deposition. And as we were pretty clear in our pre-hearing conference statement that we don't intend to issue more deposition subpoenas in connection with phase 1A. But certainly the subpoenas that we served in Mr. Bricker and Mr. Haugen say nothing about Water Code section 1100. And I would again refer you to the specific statutory authorities that are cited in those subpoena forms. None of them rely on Water Code section 1100. What I think Water Code section 1100 does is allow the board to make depositions available pursuant to the Discovery Act. And in particular, that would allow parties to adjudicated proceedings to simply issue notices of deposition rather than issuing subpoenas to party witnesses. But that's not what the state board has done. The state board has made these subpoena forms available for deposition pursuant to its authority under Water Code section 1080 and California Code of Regulations Title 23, section 649.6. That's really all there is to it. Thank you.
Thank you, Mr. Bivens. And thank you to all of you for your comments on the discovery issue. I'd like to now move to the question of rebuttal and really how rebuttal should be conducted. I realize the discovery issues, depending on how they're resolved, may affect the schedule of the hearing. So we are talking in a little bit of a hypothetical, but I would, so you can address it both ways, but I would like to have some discussion about how rebuttal might work with the current hearing dates and with the schedule as is, caveating the possibility that that may have to change depending on how the discovery issues are resolved. Based on the pre-hearing conference statements, I think everyone agrees that we should have rebuttal, and I agree we should have rebuttal. You're right to point out the amended hearing notice did not include a deadline for the submission of exhibits and written testimony in advance. And I think that's the question I'd like to focus on today, is whether rebuttal exhibits and testimony should be required to be submitted in advance. And if they are, what the timing of that should be, how that would work with our existing hearing dates. I do want to remind all of you, and this has been relevant to the discussion about scope and the scope of the phase 1A hearing, that rebuttal is really, I see it as an opportunity to respond to issues and opposing evidence that were not really anticipated, right? I mean, semi-tropics complaint is on the table. We know that's out there. Phase 1A is not necessarily limited to the specific items addressed in that complaint. That's not the way the phase 1A hearing notice is outlined. But I think the parties are on notice that the issues raised in semi-tropics complaint are the issues, at least some set of the issues that semi-tropic is going to present evidence on. So I would expect that the other parties will submit significant evidence in their case in chief, and that we're not going to backload this thing in rebuttal. Let's do it up front. That's more efficient. Let's put it all out on the table, okay? And we'll set a time schedule for that to be appropriate. That said, there certainly is a time and place for rebuttal. I understand that, and I do want to set this up so each party has an appropriate opportunity to respond. I'd like to hear from all of you how to handle that if we are keeping these putting aside the discovery issues, if we're keeping these dates, I'm really not inclined to stretch out this hearing into late June or July to accommodate rebuttal. I do want to get phase 1A done because I think the next phases of this hearing, whichever that may be, is probably going to be more complex and require more time. We're going to need more time up front to engage in motion practice, go through these exercises and prepare for the next phase. So I want to have time to do that. And I'd like to get through phase 1A so we know what the next phase of this hearing is going to be. So let's talk through this. I'll go in the same order because we've set up an order for the day. I'll start with KRWA, we'll go to Tulare Lake, we'll go to Semi-Tropic. I'm sorry, KRWA, Tulare Lake, then we'll go to Mr. Jacobs. I assume you'll have comments as well, and then Semi-Tropic, and then we'll hear from the other parties with comments on this issue of rebuttal. Should we have it, the written submittals in advance? If so, how should we structure that? How should we move forward? I realize we will probably have more information after submittal of the case in chief exhibits in May. I do plan to set up another pre-hearing conference right after that deadline so we can meet again. So our discussion today may not be final. We'll adapt moving forward depending on how things are resolved. But I'd like to hear from you now so we have some sense of what's happening. Should we start with Mr. Hughes for KRWA?
That's fine, Ms. Kinsey. My initial reaction is that it should be in advance, in terms of having a streamlined hearing. As I said before, with respect to one of the other items, all cards on the table going into the hearing. That's usually what the submission of evidence process is for. And so I would also say my initial reaction was 30 days after. I know it's a little bit inconsistent with what you just proposed in terms of timing of the hearing, but again, with the volume of what could be the initial submittal, my initial reaction was that is usually the case with any sort of, and I'm analogizing to pre-hearing or post-hearing briefing, a 30-day response deadline after the initial submittals. Because if evidence has to be gathered, exhibits, testimony, what have you, I think 30 days to do this, and I've said this before, again, with respect to another item, doing this in an orderly fashion, I think that would be most appropriate.
And will you clarify for me 30 days after the deadline for submission of cases in chief? So 30 days after the May 2nd deadline?
Yes, I'm sorry. Yeah, I'm sorry if I was unclear about that.
Thank you.
I'm looking at the schedule in front of me, and you may not be what I'm looking at. Looking at what I'm looking at. So,
thank you. Thank you, Mr. Hughes. And Mr. Keel.
I'd like to join Mr. Hughes' recommendation.
Thank you. That was very concise. Appreciate that. And Mr. Jacobs.
I agree, and I actually think 30 days will go very fast.
30 days does go fast in water board time. I agree. And we'll go to Mr. Bivens from there.
Well, I certainly agree that rebuttal testimony should be submitted in advance. Like you, Ms. Kinsey, Semi-Tropic wants to get phase 1A done and wants to get phase 1A done on the schedule that's been set. So it may be more appropriate to make it a 3-week deadline for the submission. I'm sorry, 3 weeks after the submission of cases in chief for rebuttal testimony. And I appreciate your admonition that rebuttal testimony should really be directed to new issues, and we'll certainly comply with that. But we do hope that whatever deadline you decide for rebuttal testimony, that it allows the phase 1A hearing to move forward expeditiously.
Thank you. Are there other parties who would like to comment on the rebuttal, the issue of rebuttal, and the timing of rebuttal?
This is Shonda Grady on behalf of McMullen Area Groundwater Sustainability Agency.
Yes,
and we would follow suit with the suggestion of KRWA with our one particular concern is making sure that the documents, if those are being added to the record, are first made available. Our only concern is the record being expanded and not having sufficient opportunity to access those on the schedule being proposed.
Maybe can you expound on that to make sure I understand? You're concerned about access to the exhibits that are the case in chief exhibits that are submitted, or the rebuttal exhibits?
The additional documents that have been requested to be added to the record that have not yet been made available to everybody.
And so your concern with respect to rebuttal is that making sure that those are made available in advance of, well, the case in chief deadline ideally, and also the rebuttal deadline.
Correct. Thank you.
Are there other comments? I don't see hands, so if you're waving a hand, wave it more vigorously. There are many screens. Otherwise, we'll move on, and I'll ask if there are, before we set a follow-up pre-hearing conference, are there any other procedural issues that anyone would like to raise today that we haven't yet addressed?
Ms. Kinsey, Kevin O'Brien, we're starting to think about our presentation for the hearing, and I know in previous state board evidentiary hearings, it's often been the case that, for example, technical witnesses are presented as a panel and then cross-examined as a panel. I don't know whether the AHO intends to follow that procedure, but it would be helpful for us to know whether will be part of the procedures we use in this hearing.
That's a very good point. Thank you, Mr. O'Brien. I had been thinking, of course, we'll know more, or I will know more, as of the March 30th deadline for submitting the revised, updated NOIs with a witness list. This may counsel what I'm thinking right now is maybe we should have a follow-up, hopefully brief pre-hearing conference following that deadline where we can talk about, and at that time, we may have a better sense actually of the discovery issues and how that's going. So I think what I'll do is I'll set a pre-hearing conference sooner than I was thinking. We can circle back, we can talk more about the schedule, we'll have a better sense of the schedule. I will plan to have ruled on the discovery, at least the outstanding motion by that point. And then we can, as appropriate, we can talk about witnesses, who may be working together on presenting witnesses, how those panels might work, and get into the nuts and bolts of that. I think that's a good suggestion.
Thank you.
Thank you. Are there other comments before we go now to setting this more accelerated pre-hearing conference? We can all gather sooner rather than later. Won't that be lovely? Any other comments? Then let's turn to our calendars. We have the deadline for submission of amended NOIs with witness lists is March 30th. That is a week from today. We need a chance to sort of internalize those. So I am looking at the following week in April, so it'll be 2 weeks out. April, well, I need to give myself enough time to get a procedural ruling out. So let's think about this. Let's look at the week after that, the week of April 12th. Are there any, well, we can stick with Tuesdays if there aren't conflicts. But so if we're looking at the morning of April 13th for a pre-hearing conference, are there conflicts or does that work with your schedules?
I would just like to point out that I'm hoping to have Joe Hughes at my side when our case is called on April the 12th before Judge Lampe in the Kern County Superior Court.
Yes, thank you.
Thank you, Mr. Herr. I was hoping to avoid that, but if you're going to demand my presence, then I will be there.
So maybe remind me, when does the trial begin, or what dates should we avoid?
It's currently scheduled to commence April the 12th.
Okay.
However, as I think everyone knows, because it's a court trial, I suspect we'll be at the mercy of how Judge Lampe feels on any particular day. So I would suggest that perhaps the Friday before April the 12th might be a safe date.
Yes, that's what I was looking to the week before. I have conflicts on the 8th and the 9th. Can we look to April 7th Would that work? Does anyone else have a conflict with April 7th? That puts me on a somewhat accelerated schedule to get a ruling out, but I think we can handle that. April 7th, the morning of, I'm looking at 9 o'clock. Good. Let's meet again April 7th at 9 o'clock. We will talk, well, based on what happens in the interim, we'll set our list of items based on that. And then we'll plan, depending on the schedule going from there, we'll probably plan on having another pre-hearing conference, assuming that that May 2nd deadline stands for the submittal of cases in chief. I think it may be appropriate to meet again after that. Any final comments before we adjourn for the day? We'll send out a notice for the April 7th meeting, the April 7th pre-hearing conference, so you'll have that, but it should be the same Zoom call-in information that we have been using. Thank you very much. I really appreciate your comments today. They were very helpful. Mr. Jacobs will look into that email issue and try to, if it is something on our end, we will certainly try to correct that so that doesn't happen again. Thank you for alerting me. And with that, this pre-hearing conference is adjourned. Thank you very much.
Thank you.
Thank you.
Thank you.
Thank you.